is to be tendered by way of affidavit. That is our Evidence Act. Section 111 of the Evidence Act, Your Honor, says that he who avers must prove. The state has made wild allegations of crowds forming in police stations without any proof or pretense to that effect whatsoever. Your Honor, the accused person before you is 19 years old. He was brought here by 21 armed police officers. The number of police officers who escorted him are more than his age. These police officers, Your Honor, if they had time to sit down, they would have produced an affidavit before you. You cannot come to court 21 people to say that one individual will not sit down to craft a 5-page affidavit. He is a victim of state indolence, laziness, misconception of the law, and inefficiency in the police force. The state must not benefit from its inherent laziness. Having said that, Your Honor, I give you 2 authorities so that when you retire, you consider them. It is our trite law that when you are making an application to deny bail or bond, you give cogent evidence and not mere allegations. That was the position of the High Court sitting in Mombasa in criminal case number 26 of 2008. What the prosecutor has done is what the High Court warned, that mere allegations cannot deny an accused person his right to liberty and right to be admitted to bail. And lastly, Your Honor, when you look at the charge sheet, is a poorly crafted play that is to be watched by yourself and then be convinced that crimes of serious magnitude were committed. A 19-year-old robbing a mobile phone and a battery from an armed police officer is one of the worst plays to be played in our courts. In R versus Salim Said Nasoro, criminal case number 351 of 2016, in a High Court in Milimani, the court was very clear that seriousness of the offense per se is not a reason to deny bail. Even if they are to charge him of murder or attempted murder, to make the offense appear serious before unsuspecting court users, it would not have been enough to deny him bail. We therefore pray, Your Honor, that you consider the state, including the prosecution, not to have tendered anything before you, work determination, for the reason that there is no affidavit on record, even a poorly drafted one, to demonstrate that they lacked time to do a proper one, and proceed to have the charge sheet in its present ridiculous form read, and the accused person admitted to reasonable bail terms. Rest my case.